Hello, and welcome to Finley Davies Pension Plan Termination webinar. Thank you to those who have submitted questions in advance, some of which will be answered during this webinar and others which we'll address at the conclusion. If you have questions during the webinar, please type them in the chat area accessible in the hidden toolbar at the top of your screen. We'll address all submitted questions at the conclusion of the webinar presentation. This webinar is being recorded, and the recording will be available on the Finley Davies website. You'll receive a link to the recording as well as a link to the presentation slides in the next few days. Today's topic is complex, and our goal is to make it as easy to understand as possible. So let's dive right in.
My name is Blaine Brickhouse, and I'm a pension actuary with Finley Davies. You should have received a copy of our Path to Defined Benefit Plan Termination pictured here. If not, we have a copy on our website. It may be difficult to see the details for each step, but in a few minutes, Colleen will go over each step individually in more detail. Today, we're going to start by addressing planning issues for pension plan terminations, both what we consider advanced planning and final planning. Advanced planning could be for only a few months before the plan termination starts, or as many as 5 or more years prior to the plan termination. Final planning addresses the details of the termination process and would occur a month or two before the plan termination itself starts. After a discussion on planning issues, Colleen will walk through the steps along the plan termination path, the timing of requirements for each step, and she'll discuss how the various steps are interrelated. Pension plan termination eliminates plan liabilities by distributing plan assets through a combination of lump sum payouts, rollovers, and annuity purchases. There are several types of pension terminations: standard terminations, distress terminations, and PBGC-initiated terminations. Today we're going to discuss standard terminations for single pension plans, which are voluntary. Distress terminations are for organizations which are in bankruptcy or near bankruptcy. Involuntary terminations occur when the PBGC forces a plan to terminate, usually for a plan sponsor which is in financial difficulty or which may be a risk to the PBGC program. Distress and involuntary terminations follow different procedures than standard terminations. A lot of pension plans have frozen benefits either as hard freeze or as a soft freeze. A soft freeze occurs when no new entrants enter the plan, but a portion of the plan participants continue to accrue benefits. A hard freeze occurs when all benefit accruals have stopped. Usually with a hard freeze, the ultimate goal is to eventually terminate the plan. However, there are a few exceptions for terminating the plan with a hard freeze. First, if a plan sponsor knows it will be acquiring another organization with a pension plan, they may want to merge the acquired plans into one plan if either of the plans are overfunded, which this procedure would produce minimal excise taxes on the surplus assets. Second, the plan sponsor may want to use the frozen plan as part of an early retirement incentive program. This procedure could produce more flexibility in funding the incentive program. Third, the plan sponsor may want to just temporarily freeze benefits, but then intends to restart benefits at a later date. But most of the time, once the plan is fully frozen, the goal is to eventually terminate the plan, so advanced planning is appropriate even if the plan termination is several years away. Today we're only going to cover the preparation and steps in the plan termination process once a plan sponsor is reasonably sure a pension plan will be terminated. We're not covering steps to a hard freeze or analysis of the pros and cons of terminating. Time frames. A pension plan termination is a lengthy process. Depending on the circumstances, the amount of time for data cleanup can be minimal or could require a number of months. Although legally not required, we recommend the plan sponsor request an IRS determination letter on the plan termination, but doing so does slow down the process. The total plan termination process generally takes 12 to 18 months, but in some cases it can be longer. Legal challenges can add to many months or even years to the process. If the plan sponsor does not file with the IRS but files only with PBGC, the process could range from between 6 to 12 months. Advanced planning standpoint, issues to consider include financial investment issues, plan design adjustments, data considerations, and communication. Financial considerations. Big question is additional cash needed, and if so, how much? The plan actuary should evaluate the unfunded liability on a shutdown basis, not on the IRS funded ratio basis or on an accounting basis. The IRS funded ratios reflect funding relief and significantly understate the shutdown liability. The accounting liability basis usually understates the shutdown liability as well. Any additional contributions needed to fund the shutdown liability are generally deductible except for small plans. In some cases, plans with less than 100 employees could have limited deductions for highly compensated employees. Plan sponsors should determine the period over which to fund the shortfall. They could develop a schedule and plan to fund over a period of time such as a year or two, or even like a range of 5 to 7 years. They should determine contributing more than minimum amount, whether that's desirable or not, and they should monitor the funded status over time and as conditions change. So for example, if interest rates go up significantly, that may change their time frame. One question is whether to borrow funds to fund the plan, whether that's feasible or desirable. Current low interest rates produce fixed and predictable payments if they get a loan and reduce some of the variable PBGC premium. However, interest rates are very low, so plan liabilities are higher than usual. Another consideration which is important is what is the financial statement impact on terminating the plan. A settlement charge can be quite significant. At the time the benefits are distributed, all unamortized actuarial losses become a one-time special charge to earnings. This charge is not an extraordinary item, but is a non-recurring item, and losses are primarily due to very low interest rate environment we're in and net investment experience over the last 5 years. In the current environment, settlement charge can be quite large. Making additional contributions does not reduce this loss or its recognition in the financial statement. In the current environment, the one-time charge to earnings could be in the range of 50 to 100% of plan assets, depending on the details. Investment considerations. First, always consult with the plan's investment advisor early in the process. Currently, the funding policy of an ongoing plan might be for an investment mix of 65% equity and 35% bonds, or another plan may have a mix of 50% equity and 50% bonds. The time horizon for an ongoing plan is very long, really a number of decades, so equity investments are appropriate. If the plan sponsor intends to terminate the plan in 5 to 7 years, then the time horizon becomes much shorter. They may want to change the investment policy to lower the equity percentage of assets and increase the bond percentage. They may also want to change the policy to gradually increase the bond percentage as the funded ratio increases. Once the plan termination begins, then the remaining life of the plan lowers to maybe 12 to 18 months. Continuing to invest in equities becomes a much bigger gamble, and surprisingly, in most cases, investing entirely in cash is also a big gamble since liabilities are still subject to change in interest rates. In general, a 1% decrease in long-term bond rates could increase plan liabilities 12 to 16%, depending on what the duration of liabilities are for the plan. So for example, if a plan has $1 million in assets and $1 million in liabilities, but they need to wait for this 12-month period to go through the legal process to terminate the plan, if interest rates go down to 1% during that 12-month period, the plan could be underfunded by $150,000, even though their investments are just in fixed assets. So investing in long-term bonds is of a similar duration to the plan's liability is a less likely gamble than investing in cash and minimizes the risk of the unfunded liability increasing. Plan sponsors should also determine if there are any non-liquid assets in the trust, such as hedge funds, real estate, or intangibles. If these assets cannot be liquidated, the plan termination may need to be delayed. Plan sponsors will want to avoid overfunding the plan due to excise taxes on surplus. Currently, there's a 50% excise tax for for-profit organizations and a 20% excise tax for not-for-profit organizations. The plan sponsor for for-profit organizations can reduce the 50% tax, but there's still going to be an excise tax on the reversion in the event of surplus. Plan design considerations. The plan sponsor may need to amend the plan to reflect recent law changes when the pension plan is terminated, as well as making any changes needed due to the plan termination. If unlimited lump sums were provided under the prior plan prior to the plan termination, lump sums can continue to be paid during the termination process. So the administration of the plan and lump sums are not changed because of the plan termination. If a plan has not had lump sums option available, usually adding a lump sum option for non-retirees can lower the overall liability of the plan rather than buying a group annuity for all participants. However, in this case, the lump sums would not be able to be paid until the entire plan termination has been approved at final distribution. Lump sums are generally not offered to participants already in pay status, although this is possible. A recent IRS notice has been a little bit unclear on the IRS's position on this. So if someone does want to consider paying lump sums for retirees, they definitely would want to get a determination letter to get this question resolved. If there is savings in doing this, there's less savings for paying lump sums for retirees than there are for actives, and we would suggest that really modeling of the cost both ways would be done before the plan termination has started. The IRS has just recently announced that they're going to require a more costly mortality table to be used for lump sums beginning in 2018. So if a plan termination is expected to pay out in 2018, the actuary should model whether providing lump sums is more or less costly. The plan sponsor should also review any defined contribution plan provisions regarding rollovers to be sure that if they want to have rollovers to the employer's defined contribution plan, that plan does allow for rollovers. Data questions. Data issues can be a significant problem for the plan termination process. One question is whether accrued benefits are accurate and final. If not, accurate accrued benefits should be calculated prior to the formal termination of the plan. Second, is the underlying participant data available for all participants, including vested terminations? This would include salary history and service, that type of thing. If not, can it be obtained? The PBGC understands that in some cases, due to old mergers, for example, there might not be full information for participants to see how their benefits are calculated, but it's best to document that an attempt was made to obtain this information, again, before the plan termination occurs. Vesting issues. Usually participants who have not had a one-year break in service are required by the IRS to become fully vested when the plan terminates, but it depends on the plan's language. The plan language could require a larger group of participants to become vested. And also, if there's been a significant reduction in the actives in the last 5 years, that could also trigger vesting. It just depends on facts and circumstances. Another question is whether addresses are up to date. The plan sponsor should use a locator service to obtain addresses for missing participants and alternate payees. The PBGC can assume the liability for participants that are missing, but the plan sponsor must show that they've gone through a bona fide effort to locate missing participants in case for that to occur. All qualified domestic relationship orders should also be reviewed. For communications, formal notice of the plan termination must be provided between 60 and 90 days prior to the proposed termination date. Notice of a benefit freeze, if the plan has not already been frozen, must be provided at least 45 days before the freeze. We always recommend that the plan be frozen as well at the same time it's terminated if it's not already been frozen, so that in the event the plan termination is later voided, whether it's voluntarily or involuntarily, benefit accruals will not be reactivated in that case. We recommend that when the plan is terminated, or even before the plan is formally terminated, any new plan, 401k plan or 403b plan, or any enhancements should be communicated to plan participants so they get a picture of what the new retirement program would be, as opposed to just freezing the plan and then a year later coming back with changes for the 401k plan. Also, there should be consideration of whether there are any union issues, workforce reduction issues, community issues, or other public relation concerns. And of course, in a union plan, the union's agreement is required in order to terminate the plan. For final planning, when a plan sponsor reaches the agreed upon trigger point, such as a 90 or 95% funded ratio, they should start discussing the final steps in planning for a plan termination. The plan sponsor should establish relationships with an annuity consultant who will solicit annuity bids and usually act as fiduciary to the plan. This fiduciary would document that the plan sponsor had selected an insurance company which meets the DOL's definition of safest annuity provider. As we've been discussing, there are many steps to the process, and a plan sponsor will need the plan's outside consultants and attorney to assist them. Plan terminations are a big project and quite expensive. However, we have come across situations where current consultants have quoted extremely high fees for terminating a plan. If a plan sponsor believes the fees are unreasonable, they may want to seek fee estimates from other actuaries. During the plan termination process, this 12 to 18-month period, most ongoing administrative requirements continue to apply. The plan still needs to file Form 5500s, even though no actuarial evaluation or Schedule B is required. PBGC filings also continue, although the per participant premium still applies, but the variable premium does not apply. The plan still needs a plan audit if it needed a plan audit before, and financial reporting continues. So the regular benefit administration continues as participants retire or terminate, just as under normal circumstances. Once the plan termination process is started, though, the actuarial funding evaluation for minimum funding and the annual funding notices themselves are not required to be provided. Plan sponsors should plan ahead for the extra administrative resources needed to manage the plan termination, taking into account all of the required participant notifications, participant election processing, and phone calls, and they should consider the cost of outsourcing versus insourcing these functions. Also, early in the process, let the trustee know when the final distributions are expected. They will need lead time to prepare for the large volume of lump sum payments, if lump sum payments are paid, and for the final annuity purchase. Most, if not all, plans with over 100 participants are usually audited by the PBGC after distribution is made, sometimes months later. So you really ought to always expect that there will be a post-distribution audit by the PBGC, and therefore document all the plan termination work and be prepared for an audit. And the work must be maintained for 6 years following distribution. So as a summary, it's critical to understand and prepare for the plan termination process. Establishing a timeline with target dates, required deliverables, and the responsible parties is key to a successful plan termination. Colleen will now go into the details of the plan termination process.
Good morning, everyone. I'm Colleen Lowmiller. I'm a senior consultant with Finley Davies. Blaine went over all of the pre-planning, and once you've gone through all your preparations and you've reached the point when everything is ready, you'll then begin the plan termination process, starting with adopting a board resolution to terminate and then formally amending the plan document to terminate. So this sets the proposed plan termination date, which is the beginning of the plan termination. The process actually ends when the last benefit is paid from the plan. As Blaine discussed, you'll also want to add lump sum options in this amendment if that's what you've decided. You'll need to send a notice of intent to terminate to all participants at least 60 days but not more than 90 days prior to that proposed termination date that you set. And for distributing this notice and all the other required notices during this process, the participants you'll need to make sure you include are, of course, the active employees with benefits and terminated employees that are vested in the plan, as well as retired employees receiving benefits. But also remember to include beneficiaries of deceased employees and any alternate payees that are assigned benefits through a quadro. There's also, we included here, the Notice of State Guarantee Association's coverage for annuities. So this is a notice that we included here so that we're combining mailings. We're combining the administrative effort on one of the plan termination mailings. It's required to be sent at least 45 days prior to when annuities are purchased, which is towards the end of the process, but this is as good a time as any other to send this notice. You could send it with, decide to send it with one of the other notices that you have to mail out. So I'm going to cover the next 4 steps along the path to termination together due to their interrelated timing. And if you follow our advice and file with the IRS for a determination letter that the plan is qualified and the plan document is in order, you need to let participants and other interested parties like union reps, for example, know that you're doing the filing by sending a notice to interested parties 7 to 21 days prior to those filings, if doing by posting or email, and it's 10 to 24 days if you're using regular mail. That IRS filing includes Forms 5310 and 6088. And now these have no specific due date, but we recommend that you file them first because the IRS has the longest waiting period. It also should be filed before the filings are made with the PBGC so that you have the option of waiting to hear back from the IRS before you're required to start distributing benefits. And the next mailing to participants is the Notice of Plan Benefits. And this is the big mailing that they get that includes all of the plan information specific to them. So it includes information about the plan termination, but it also includes their benefit at several commencement dates, estimated lump sum amounts if your plan pays them or if you're adding them during the termination. It includes all the data used to calculate their benefits. So going back to what Blaine mentioned on making sure you have the data behind all of the benefits, that you need them here in this notice. And then it includes an explanation of the benefit formula and other plan provisions in layman's terms. Then within 180 days of that proposed termination day that you set, the PBGC Form 500 has to be filed, and that provides the PBGC with certain information on the plan. It has the estimated termination liability and certification that the plan will be sufficiently funded to provide all benefits. Now for these steps, there's other timing possible, but we feel that this order of tasks is ideal, with the first three steps here occurring prior to the PBGC Form 500 filing. So you've gone through those last 4 steps, which is a big part of the administrative effort of a plan termination. And now you're hitting the point where basically you can sit back and relax. You've hit the review period or the waiting period, which can be long, as we've mentioned, and it ends on the later of 2 events. The first event is the expiration of the PBGC's review period, and that runs from when you filed the Form 500 filing to 60 days later, but the PBGC can extend that period. Once that review period ends, the plan termination is deemed approved unless you receive a notice of non-compliance. Now, what you're hoping for here is that this is actually a non-event because it's a no news is good news situation. The second event is when you receive the termination letter from the IRS, which is based on the IRS's schedule, and you should plan on 9 to 12 months, but as we've mentioned, it could be longer. So if you only filed with the PBGC, not the IRS, then you have 180 days to get benefits distributed after the waiting period expires. Assuming that you filed with the IRS, once you receive that favorable determination letter, you have 120 days within which to purchase the annuities and pay the lump sums. So at that point, you'll need to distribute election forms to participants so that they have at least 30 days prior to distribution date. And then also during that 120-day window will be when final bidding with insurance carriers is going to occur as participant election forms come in and the actual annuities that need to be purchased are known. Then once all benefits are paid out of the plan, the PBGC Form 501, which is a post-distribution certification, is due within 30 days. So once you've reached this point, you're in the home stretch. The final Form 5500 is due within 7 months of all trust assets being distributed. Now note that this date is no longer based on the end of the plan year, but based on when the assets have been distributed. And then it's not listed here, but also remember to file the final PBGC premium filing. So key takeaways are that financial data, communications, and business objectives, as well as market conditions, impact your decision to start the plan termination process. Once you start, the plan termination typically takes at least 12 to 18 months, but it could be longer. So expect it's going to take time. The devil's in the details, and be prepared for obstacles along the way. Some examples of obstacles would be during the review period, the IRS is asking for more information, or perhaps you find issues with the benefits for a portion of the population, no matter how prepared you think you were before you started. It happens. And then as participants are contacting, you may find out that there's different data. Maybe something isn't quite right with some of the participants' records, or a quadro shows up out of the blue that you didn't know about before, or you're notified about a participant who died, and so you need to work out who are the beneficiaries and what might be due. So there's a lot of different things that can happen, even as prepared as you try to be. So just, be prepared for obstacles, and you'll handle them as they come up.
Okay, thanks Colleen and Blaine. So we've covered quite a bit in a short amount of time, and first I'd like to address the questions that we received in advance of the session, and then we'll follow with questions. I see we have a couple in the chat window too. So if we go over our time, we'll remain on the line until all the questions are answered, but we understand if you have other commitments and need to drop off. So first question was, can you please provide some examples of settlement options? Blaine, you want to take that one?
Okay, I'll answer that. One option would be that just to purchase a group annuity that duplicates exactly what the old plan provisions are. So all the options that would in the plan currently would be provided through the group annuity contract. If the plan had lump sum options, that actually would transfer to the group annuity contract as well. If you have lump sums that are available during the plan termination, which we see most of the time, then participants will have the lump sum, and by lump sum I would mean direct lump sum that would be cash, 20% excise federal withholding on that, and also potential 10% excise tax. But that would also include rollovers to an IRA or over to another qualified plan. I have seen some plans where the plan sponsors wanted to only give active participants the choice of a rollover to their own 401k plan. The IRS rules don't specifically permit that, but I've never had a problem where the IRS has said they couldn't do that. So that's something that you want to get a termination letter on to be sure of, but that's an option. I have seen in a few rare cases where pension plans that actually had some employer stock, actually distributed stock in the process. That's possible, but obviously there's SEC issues that need to be involved in that also. So those would be the various types of options. One other thing happens though if you open up a lump sum to someone who's prior to early retirement age is they have to be given all the monthly annuity options, at least the life annuity and joint survivor options as an annuity, even if they are not eligible for early retirement. So that's just a general IRS requirement.
Okay. All right. So now one of the chat window questions, given capacity issues with insurers, is there a best time to distribute benefits? Blaine, you want to take that one too?
Yes. Once all the approvals, the government approvals are done, you don't have much flexibility on the timing of when to buy annuities. My experience I've had is that probably the month of January is not a good time with insurance companies. They get other work that they've got to do, so it's a little more difficult. But also later in the year, as the year progresses, after the fall, if insurers have reached their capacity, you may get less bids, or either less bids or less competitive bids. So I'd say generally, if you have the choice, doing it between February up through August or September is probably a better time to go through annuity bids.
Okay. Next question is, once a plan termination starts, can it be stopped if the plan sponsor cannot afford to pay off the underfunded benefits?
I can take that one. So, yes, the termination can be stopped any time prior to when distribution starts, but this gets to the preparation and planning, working to know, the plan's underfunding as you're headed in. But yes, if something unexpected happens, you can stop it.
Okay. And the last question that we've got here so far is, if a plan is underfunded, can the plan sponsor take some of the excess funds out before the final distributions are made?
I think that's if the plan is overfunded, so if there's excess funds in the plan.
Yeah, right.
So the answer to that is no. And once distributions have been made, there's, as Blaine mentioned, there's large excise taxes on any surplus that the plan sponsor might receive back. It's called a reversion. It's 50% excise tax for for-profit organizations and 20% for not-for-profit. Now, for for-profit, the excise tax can be reduced, but only by sharing some of the excess with the participants. And you should also look at the plan document, because sometimes the plan termination provisions indicate how a surplus should be handled.
All right, that's all the questions we've received. So feel free to call, or email Blaine or Colleen if you'd like to talk in more detail about some of your specific questions. And thanks for joining us, and I look for the recording to be available soon.